The United States District Court for the Southern District of New York occupied the federal courthouse at Foley Square in Lower Manhattan, a neoclassical building completed in 1936 with massive Corinthian columns and a facade designed to project authority and permanence. On the morning of October 14, 1952, the building's corridors echoed with footsteps of attorneys, clerks, defendants, and witnesses moving between courtrooms and offices. The marble floors reflected the overhead lights. The walls displayed portraits of judges and legal figures from the district's history. The atmosphere was formal, institutional, designed to reinforce the gravity of federal legal proceedings. At 9:30 that morning, Ellsworth Raymond Johnson entered courtroom 318 on the building's third floor. He was 46 years old, dressed in a dark suit, a white shirt and conservative tie that his attorney had insisted he wear to present a respectable appearance before the judge and jury. Johnson's physical appearance was unremarkable. 5 feet 10 inches tall, lean build, short hair, calm expression. The bump on the back of his head that had given him his nickname was not visible from the front. To observers who did not know his reputation, he might have appeared to be simply another defendant in the federal criminal justice system. Johnson was accompanied by his attorney, David Rothstein, a 42-year-old criminal defense lawyer who maintained an office on Center Street near the courthouse. Rothstein had represented Johnson in previous legal matters and understood both Johnson's intelligence and the challenges of defending a black man with a criminal record in the federal court system. They took seats at the defense table, a heavy wooden structure positioned to the left of the courtroom's central aisle. The prosecution table was occupied by 2 assistant United States attorneys, both white men in their 30s, who had been assigned to the case by the U.S. Attorney's Office. They carried briefcases containing evidence, witness statements, and legal memoranda related to the government's case against Johnson for conspiracy to distribute heroin. The case had been developed over 8 months through surveillance, informant testimony, and coordination with the Federal Bureau of Narcotics. The courtroom filled with spectators. Some were Johnson's associates from Harlem. Others were reporters covering the trial. Some were simply citizens observing federal court proceedings. The jury box contained 12 jurors who had been selected the previous week. 11 white, 1 black, representing the demographics of the federal jury pool in 1952 New York. The bailiff called for order as the court prepared for the presiding judge to enter. At 9:45, the door to the judge's chambers opened, and the Honorable Richard Caldwell entered the courtroom. The bailiff announced his arrival, and everyone in the courtroom stood as required by protocol. Judge Caldwell was 62 years old, a federal judge who had been appointed to the Southern District Bench in 1948 after serving as a prosecutor and then as a partner in a Wall Street law firm. He wore black judicial robes and carried himself with the dignity and authority expected of his position. He took his seat at the elevated bench that positioned him above all other participants in the courtroom, symbolizing the hierarchy of the judicial system. Judge Caldwell instructed everyone to be seated and called the proceedings to order. He stated that the court would hear closing arguments in the case of United States versus Ellsworth Raymond Johnson, and that following those arguments and the judge's instructions on applicable law, the jury would deliberate to reach a verdict. The judge's voice was firm and professional. His demeanor suggested complete confidence in his authority and in the legitimacy of the proceedings over which he presided. The Assistant United States Attorney delivered the government's closing argument over 45 minutes. He summarized the evidence that had been presented during the 3-week trial. Testimony from a confidential informant who claimed Johnson had coordinated the distribution of heroin in Harlem. Surveillance reports documenting Johnson's meetings with individuals known to be involved in narcotics trafficking, testimony from Federal Bureau of Narcotics agents describing patterns consistent with drug conspiracy, financial records suggesting Johnson had income that could not be explained through legitimate means. The prosecutor emphasized Johnson's criminal record, his known association with organized crime figures, his reputation as a powerful figure in Harlem's illegal economy. The prosecutor argued that the evidence demonstrated beyond reasonable doubt that Johnson had conspired with others to distribute heroin, a serious federal crime that threatened communities and justified substantial punishment. The prosecutor requested that the jury find Johnson guilty on all counts. David Rothstein delivered the defense closing argument. He challenged the credibility of the government's confidential informant, noting that the informant had received payment and favorable treatment in his own criminal case in exchange for testimony. He questioned the surveillance evidence, arguing that meetings between individuals did not prove criminal conspiracy. He pointed out inconsistencies and gaps in the government's case, and he reminded the jury that Johnson was entitled to presumption of innocence and that the government bore the burden of proving guilt beyond reasonable doubt. But Rothstein faced significant obstacles. The jury was almost entirely white, hearing a case against a black defendant with a criminal history. The judge had made several evidentiary rulings during the trial that favored the prosecution, allowing questionable testimony while restricting some defense evidence. The Federal Bureau of Narcotics had invested substantial resources in building the case and was determined to secure a conviction. The political climate in 1952 favored aggressive prosecution of narcotics offenses, particularly in black neighborhoods where drug trafficking was framed as both a criminal problem and a racial problem. After the closing arguments concluded, Judge Caldwell provided jury instructions explaining the legal standards that governed their deliberations. He explained the elements of conspiracy that the government needed to prove. He explained the concept of reasonable doubt. He explained that if the jury found the evidence sufficient to establish guilt beyond reasonable doubt, they should return a guilty verdict, and if they found the evidence insufficient, they should return a not guilty verdict. But Judge Caldwell's instructions contained subtle language that favored the prosecution. When explaining reasonable doubt, he emphasized that it did not mean absolute certainty and suggested that jurors should not set impossibly high standards for the government's proof. When explaining conspiracy, and he provided examples that made it easier for jurors to infer criminal agreement from circumstantial evidence. These subtle biases in jury instructions could significantly influence how jurors evaluated evidence, and Rothstein recognized them but could do little to counteract their effect in the moment. The jury retired to deliberate at 2:30 in the afternoon. Johnson and Rothstein waited in a small attorney conference room adjacent to the courtroom. Johnson sat quietly, his expression neutral. He understood that the verdict was likely to be guilty. The composition of the jury, the judge's rulings, the political climate, and his own reputation made acquittal unlikely regardless of the actual evidence. Rothstein explained that if the verdict was guilty, they would appeal based on various legal issues. But he also cautioned that federal appeals rarely succeeded in overturning convictions. At 4:15, the bailiff notified them that the jury had reached a verdict. They returned to the courtroom. The jury foreperson, a white man in his 50s who worked as an accountant, stood when instructed by Judge Caldwell and announced that the jury had found Ellsworth Raymond Johnson guilty on all counts of conspiracy to distribute heroin. Judge Caldwell thanked the jury for their service and dismissed them. He scheduled sentencing for November 3, 1952, and remanded Johnson to federal custody pending sentencing. Federal marshals approached Johnson, placed him in handcuffs, and escorted him out of the courtroom through a side door that led to the courthouse lockup. Johnson walked without resistance, his face showing no emotion. He glanced once at the spectators from Harlem who had attended the trial, then disappeared through the door. Rothstein gathered his files and left the courtroom, understanding that his client had been convicted in a proceeding that, while technically lawful, had been influenced by factors beyond the actual evidence: racial bias, political pressure, prosecutorial advantages, and judicial rulings that systematically favored the government. Whether Johnson was actually guilty of the charges was almost beside the point. The system had operated as it typically operated in cases involving black defendants accused of serious crimes. Johnson spent the next 3 weeks in the Metropolitan Correctional Center in Lower Manhattan awaiting sentencing. During that time, he thought carefully about what had occurred during the trial. That he had observed Judge Caldwell's conduct throughout the proceedings. He had noticed the pattern of rulings that favored the prosecution. He had observed the judge's tone when addressing the prosecution versus when addressing the defense. He had noticed subtle indicators of bias that shaped the trial's outcome. But Johnson also thought about something more specific that had troubled him during the trial. On 2 occasions during recesses, Johnson had observed Judge Caldwell speaking quietly with a man Johnson recognized, Anthony Corsaro, an associate of the Genovese crime family who worked as a liaison between the Italian mob and various institutions including labor unions, businesses, and occasionally law enforcement or courts. Corsaro had no apparent reason to be at Johnson's trial. He was not a witness, not a defendant, not an attorney. Yet Johnson had seen him speaking with Judge Caldwell in the courthouse corridor during the morning recess on October 8th, and again in a quiet corner near the courthouse cafeteria during lunch recess on October 10th. These observations troubled Johnson because they suggested a possibility he had not initially considered, that the trial's outcome had been predetermined not just by systemic bias, but by specific corruption. If Judge Caldwell had a relationship with a mob associate, and if the Italian families wanted Johnson removed from Harlem to reduce competition or to eliminate a powerful independent black operator, then Caldwell's pattern of pro-prosecution rulings might not have been simply bias, but deliberate sabotage designed to ensure Johnson's conviction. Johnson did not share these observations with his attorney during the trial because he had no proof, and making accusations of judicial corruption without evidence would have been counterproductive. But the observations remained in Johnson's mind, and during the 3 weeks in the Metropolitan Correctional Center, he thought systematically about how to determine whether Caldwell was corrupt and, if so, how to expose that corruption. On November 3, 1952, Johnson appeared before Judge Caldwell for sentencing. Rothstein argued for leniency, noting Johnson's family circumstances and his role in the Harlem community. The Assistant United States Attorney argued for a severe sentence, noting Johnson's criminal history and the seriousness of narcotics offenses. Judge Caldwell delivered a sentence of 15 years in federal prison, stating that Johnson represented a continuing danger to society and that substantial punishment was necessary to protect communities and to deter others from similar crimes. Johnson listened to the sentence without visible reaction. He was remanded to federal custody to begin serving his sentence. But as the marshals prepared to escort him from the courtroom, Johnson looked directly at Judge Caldwell and held his gaze for several seconds. Caldwell met Johnson's eyes briefly, then looked away. Johnson said nothing, but the exchange conveyed meaning. Johnson's stare communicated that he had observed something significant, and Caldwell's aversion suggested awareness that he had been observed. Johnson was transferred to begin serving his sentence, initially at the federal penitentiary in Lewisburg, Pennsylvania, while his appeal was processed. The appeal, filed by Rothstein in early 1953, challenged various evidentiary rulings and jury instructions from the trial. The appeal argued that Judge Caldwell had committed reversible error by allowing unreliable testimony, by restricting legitimate defense evidence, and by providing jury instructions that improperly favored the prosecution. The United States Court of Appeals for the Second Circuit denied Johnson's appeal in January 1954. The appellate decision stated that while some of Judge Caldwell's rulings were questionable, they did not constitute reversible error, and that the evidence had been sufficient to support the jury's guilty verdict. This meant Johnson's conviction was final, and he would serve the 15-year sentence, minus any time reduced for good behavior. In April 1954, Ed Johnson was transferred to Alcatraz Federal Penitentiary in San Francisco Bay, California. He became inmate number 1117. Alcatraz was reserved for federal prisoners considered too dangerous, too influential, or too escape-prone for other institutions. Johnson's transfer there reflected the Bureau of Prisons' assessment that he was a high-risk inmate who needed to be isolated from his power base in Harlem and subjected to the most secure confinement available. During his first months at Alcatraz, Johnson adapted to the prison's rigid routine, but he also continued thinking about Judge Caldwell and the possibility that his conviction had resulted from corruption rather than simply from systemic bias and prosecutorial advantage. Johnson understood that even if Caldwell had been corrupt, or exposing that corruption from inside a maximum security prison would be extraordinarily difficult. But Johnson also understood that he had time, years of it, and that patient, systematic effort could sometimes accomplish what immediate action could not. Johnson began by gathering information. Through correspondence with his wife Mamie and with associates in Harlem, he learned what he could about Judge Caldwell's activities after Johnson's trial. He learned that Caldwell continued to preside over cases in the Southern District, that Caldwell maintained chambers at the Foley Square courthouse, that Caldwell lived in a townhouse in the West Village, that Caldwell was known to socialize with prominent attorneys and businessmen. Johnson also learned more about Anthony Corsaro, the mob associate he had observed speaking with Caldwell. Corsaro continued to operate as a liaison for the Genovese family, maintaining relationships with union officials, business leaders, and various individuals who could be useful to organized crime. Corsaro was not a violent enforcer or a high-profile figure. He was a facilitator who arranged meetings, delivered messages, and managed relationships that the mob wanted to cultivate. Through a former associate who visited Johnson at Alcatraz in 1955, Johnson learned something particularly significant. Corsaro had been seen meeting regularly with Judge Caldwell, not just around the time of Johnson's trial, but continuing afterward. They met at discreet locations, quiet restaurants, private clubs, locations where their meetings would not attract attention. This pattern suggested an ongoing relationship rather than isolated contacts. Johnson instructed his associate to gather more information about these meetings, when they occurred, where, who else might be present, what the circumstances suggested about their purpose. The associate agreed to document what he could observe. Over the following year, the associate provided information through letters that were carefully worded to avoid explicit accusations that might attract prison censors' attention. By mid-1956, Johnson had accumulated enough information to conclude that Judge Caldwell likely had a corrupt relationship with the Genovese family mediated through Corsaro. But information was not proof, and accusations without proof would be dismissed or could expose Johnson's associates to retaliation. Johnson needed evidence that could withstand scrutiny, documentation, recordings, or testimony that could demonstrate Caldwell's corruption clearly enough to force institutional action. Johnson identified a potential opportunity. His associate reported that Corsaro and Caldwell met regularly on the third Tuesday of each month at a private dining room in an Italian restaurant on Thompson Street in Greenwich Village. The meetings occurred in the evening, typically around 7:30, and lasted approximately 90 minutes. The pattern was consistent enough to suggest routine rather than coincidental encounters. Johnson conceived a plan to record one of these meetings. Recording technology in 1956 was limited compared to later decades, but portable recording devices did exist. A wire recorder, a device that recorded sound on magnetic wire, could be concealed in a briefcase or similar container and could capture conversations in a room if positioned properly. The device was not perfect. Sound quality depended on conditions, and positioning required planning, but it could produce usable recordings. Johnson could not execute this plan himself from Alcatraz, but he could coordinate it through trusted associates. He sent careful instructions through correspondence, using indirect language that would not reveal the plan's specifics if letters were read by prison authorities. He identified a specific associate in Harlem, Marcus Thompson, a 41-year-old former numbers operator who had worked with Johnson for years and who was intelligent, disciplined, and capable of executing a complex plan. Thompson understood that recording a conversation without consent raised legal issues, but he also understood that exposing judicial corruption potentially served larger public interests. In December 1956, Thompson obtained a wire recorder through a contact who had access to surveillance equipment. Thompson conducted tests to ensure he could operate the device effectively and that it produced clear recordings. In January 1957, Thompson prepared to record the next monthly meeting between Corsaro and Caldwell. The challenge was positioning the recording device in the private dining room where they met. The restaurant was owned by an Italian family with connections to organized crime, which meant Thompson could not simply enter and place equipment without being noticed and questioned. Thompson identified an alternative approach, and he learned that the private dining room shared a wall with a storage room that contained restaurant supplies. The storage room was accessed from a service corridor that employees used, but that was not heavily monitored. If Thompson could position the recording device in the storage room against the shared wall, and if the device was sensitive enough, it might capture conversation from the adjacent dining room. On January 15th, 1957, at 6:30 in the evening, Thompson entered the restaurant through the service entrance, dressed in the kind of clothing a delivery person might wear. He carried a briefcase containing the wire recorder. He moved quickly through the service corridor to the storage room, entered, and positioned the recording device on a shelf against the wall shared with the private dining room. He activated the recorder, set it to run for 2 hours, and left the restaurant through the same service entrance. Thompson returned at 9:45 to retrieve the device. The recording had captured approximately 2 hours of sound from the adjacent room. The sound quality was imperfect. Voices were somewhat muffled, there was ambient noise, some portions were difficult to understand, but significant portions of the conversation between Corsaro and Caldwell were audible and comprehensible. Thompson brought the recording to a technician he trusted, who transferred it from the wire recorder to a more permanent format, and who worked to enhance the audio quality using available techniques. The enhanced recording was clearer, though still imperfect. Thompson listened to it carefully and documented what he heard, and the recording captured Corsaro and Caldwell discussing various matters. Some of the conversation was social, talk about restaurants, sports, mutual acquaintances. But a significant portion addressed business matters. Corsaro referenced arrangements that had been made regarding various situations. Caldwell acknowledged these arrangements and discussed upcoming cases on his docket that might be relevant to our friend's interests. Most significantly, the recording captured Corsaro making a reference to the Harlem situation last year and thanking Caldwell for handling it appropriately. Caldwell responded that the outcome was as expected and that Mr. Genovese was satisfied with how things were concluded. This exchange, while not explicitly naming Johnson, clearly referenced a case involving Harlem that had been handled by Caldwell in a way that satisfied Genovese crime family interests. The recording also captured discussion of payment. Corsaro mentioned that the usual arrangement will continue and referenced a specific dollar amount, $5,000 monthly, that would be delivered as before. Caldwell acknowledged this arrangement without objection, suggesting it was routine. Thompson provided this recording to Johnson during a visit to Alcatraz in February 1957, using a method of communication that avoided prison monitoring. Johnson listened to a portion of the recording that Thompson had transcribed and confirmed that it appeared to document corrupt coordination between Caldwell and the Genovese family. Johnson now had evidence, though imperfect, that could potentially be used to expose Caldwell's corruption. But Johnson also understood that simply releasing the recording publicly would not necessarily produce the desired outcome. Caldwell could claim the recording was fabricated, could argue that the conversation was taken out of context, could use his position and reputation to discredit accusations from a convicted felon serving time at Alcatraz. The recording needed to be presented in a context where it would receive serious attention and where institutional forces would be compelled to investigate. Johnson developed a strategy for using the recording that involved building a coalition of allies who could validate its significance and who could apply pressure through multiple channels. The strategy would take time to execute, but Johnson had time. And he would remain at Alcatraz for years, but his associates could act on his behalf to position the recording for maximum impact. The first ally was David Rothstein, Johnson's attorney, who had continued to represent Johnson's interests after the conviction. Johnson contacted Rothstein and explained that evidence had been obtained suggesting Judge Caldwell might have been corrupt during Johnson's trial. Rothstein listened carefully to the recording and concluded that while it did not prove definitively that Caldwell had taken specific actions to ensure Johnson's conviction, it strongly suggested a corrupt relationship between Caldwell and organized crime that raised serious questions about Caldwell's conduct in all cases he had handled. Rothstein agreed to use the recording as the basis for a motion for a new trial based on newly discovered evidence. Such motions rarely succeeded, but the recording provided grounds to argue that Johnson's trial had been fundamentally unfair because the judge had been subject to corrupt influence. The second ally was a journalist named Robert Mitchell, who covered legal affairs for the New York Herald-Tribune. Mitchell had written about judicial corruption in New York courts and was known for serious investigative reporting rather than sensationalism. Rothstein contacted Mitchell and provided him with access to the recording, explaining its significance and its implications for judicial integrity. Mitchell listened to the recording and recognized it as potentially major story. A federal judge accepting payments from organized crime and coordinating case outcomes with mob interests would be a scandal of significant proportions. Mitchell began investigating independently, seeking to verify the recording's authenticity and to develop additional evidence of Caldwell's corruption. The third ally was Congressman Adam Clayton Powell, Jr., who represented Harlem in the U.S. House of Representatives. Powell had been elected in 1945 and had become a prominent voice on civil rights and social justice issues. Powell had followed Johnson's case with interest, recognizing that Johnson's conviction was seen in Harlem as potentially unjust. Rothstein contacted Powell's office and provided information about the recording and its implications. Powell recognized that judicial corruption affecting a high-profile case involving a black defendant from Harlem raised serious civil rights concerns. If Johnson had been convicted because a judge was being paid by the mob to ensure that outcome, it represented not just individual corruption, but systemic injustice. Powell agreed to use his congressional position to call for investigation of the allegations. The fourth ally was the New York Civil Liberties Union, an organization that focused on protecting constitutional rights and challenging governmental abuses. Rothstein contacted the NYCLU and provided information about the Caldwell recording. The organization's leadership concluded that allegations of judicial corruption warranted investigation and that the NYCLU should support efforts to expose the corruption and to secure a new trial for Johnson if the allegations were substantiated. With these allies identified, the strategy proceeded in coordinated stages. In April 1957, Rothstein filed a motion for a new trial in the Southern District Court, arguing that newly discovered evidence suggested Judge Caldwell had been subject to corrupt influence during Johnson's trial. The motion included a transcript of the recording and argued that the recording raised serious questions about whether Johnson had received a fair trial before an impartial judge. The motion was assigned to Judge Caldwell himself on following standard procedure in which post-conviction motions are typically handled by the judge who presided over the original trial. This created an obvious problem. Caldwell would be evaluating a motion that accused him of corruption. Rothstein anticipated this and included in the motion a request that Caldwell recuse himself and that the motion be assigned to a different judge. Caldwell denied both the motion for recusal and the underlying motion for a new trial. In a written decision issued in May 1957, Caldwell stated that the recording was inadmissible because it had been obtained without consent in violation of federal wiretapping laws. He stated that even if the recording were considered, it did not prove that he had taken any specific corrupt action in Johnson's case. And he stated that conversations between judges and members of the public were not inherently improper, and that Johnson's accusations were based on speculation and were designed to undermine the legitimacy of his conviction. Caldwell's decision to deny the motion was legally defensible. Recordings obtained without consent did face admissibility challenges, and the recording did not prove definitively that Caldwell had taken specific actions to ensure Johnson's conviction. But Caldwell's decision to rule on a motion that accused him of corruption, rather than recusing himself, created an appearance of self-interest that supported arguments about his lack of impartiality. On May 20, 1957, Robert Mitchell published the first of a series of articles in the New York Herald Tribune investigating allegations of judicial corruption in the Southern District. The article described the recording of Judge Caldwell meeting with a known organized crime associate, discussed the apparent reference to arrangements regarding cases, and raised questions about whether Caldwell had compromised his judicial independence. The article did not accuse Caldwell of specific crimes. Mitchell was careful to present the information as raising questions rather than proving guilt, but the article made clear that serious allegations about a sitting federal judge warranted investigation. The article described the recording, quoted relevant portions, and explained why the conversation suggested potential corruption. And the article generated significant attention. Other newspapers followed up with their own coverage. The New York Times published an editorial calling for investigation of the allegations. Legal ethics experts were interviewed and stated that if the allegations were true, they would represent a fundamental violation of judicial ethics and would justify removal from the bench. On May 28th, Congressman Powell gave a speech on the House floor calling for investigation of allegations regarding Judge Caldwell. Powell emphasized that judicial corruption undermined public confidence in the legal system and disproportionately harmed minority defendants who already faced systemic disadvantages in courts. Powell called on the Department of Justice to investigate and called on the federal judiciary to review Caldwell's conduct. On June 3rd, the New York Civil Liberties Union issued a public statement supporting investigation of the Caldwell allegations and calling for Johnson to receive a new trial before a different judge if the allegations were substantiated. The statement emphasized that all defendants, regardless of their background or reputation, were entitled to fair trials before impartial judges, and that evidence suggesting judicial corruption required serious attention. These combined pressures, the legal motion, the media coverage, the congressional attention, the Civil Liberties Organization's statement, created a situation where the federal judiciary could not simply ignore the allegations. The Judicial Council of the Second Circuit, which provided oversight of federal judges in the circuit, and announced in mid-June that it would review the allegations regarding Judge Caldwell. The Judicial Council's review was conducted confidentially, following standard procedures for judicial misconduct investigations. The council reviewed the recording, interviewed Rothstein and others familiar with the allegations, and examined Caldwell's financial records and calendar to determine whether evidence supported claims of corruption. The investigation was complicated by the fact that the recording had been obtained without consent, which raised questions about its admissibility and reliability. But the Judicial Council concluded that even if the recording could not be used as evidence in a criminal prosecution, it raised sufficient concerns about Caldwell's conduct to warrant further inquiry. In August 1957, the Judicial Council interviewed Caldwell and asked him to explain his relationship with Anthony Corsaro, and the conversation captured on the recording. Caldwell initially claimed that he did not know Corsaro well, and that any meetings had been coincidental. But when confronted with evidence of regular monthly meetings over extended periods, Caldwell's explanation became less credible. In September 1957, additional evidence emerged that strengthened the case against Caldwell. Federal investigators examining Caldwell's financial records found deposits that appeared inconsistent with his judicial salary and that corresponded temporally with the monthly meetings with Corsaro. While these deposits did not prove definitively that Caldwell was receiving payments from organized crime, they supported that inference. On October 15, 1957, Judge Richard Caldwell announced his resignation from the federal bench, effective immediately. The announcement stated that Caldwell was retiring for personal reasons and to pursue other opportunities. No mention was made of the corruption allegations or the ongoing investigation, but everyone familiar with the situation understood that Caldwell's resignation was not voluntary, but was the result of pressure from the Judicial Council and the Department of Justice. The resignation meant that Caldwell would not face formal disciplinary proceedings or criminal charges. This was standard practice in cases of judicial misconduct. Judges who resigned before facing formal action typically avoided prosecution in exchange for leaving the bench quietly. The federal judiciary preferred this approach because it removed corrupt judges while avoiding public scandals that might undermine confidence in the entire judicial system. On November 12, 1957, David Rothstein filed a renewed motion for a new trial for Johnson, this time assigned to a different judge in the Southern District. The motion argued that Judge Caldwell's resignation following corruption allegations demonstrated that Johnson's original trial had been tainted by judicial misconduct. The motion requested that Johnson's conviction be vacated and that he receive a new trial before an impartial judge. The new judge assigned to consider the motion was Judge Lawrence Winters, a respected jurist who had served on the Southern District bench since 1952. Judge Winters reviewed the motion carefully. He recognized that Caldwell's resignation created strong inference that something had been improper, even if the specific details could not be proven definitively. He also recognized that allowing Johnson's conviction to stand when serious questions existed about the trial judge's impartiality would undermine public confidence in the justice system. On January 20th, 1958, Judge Winters issued a decision granting Johnson's motion for a new trial. The decision stated that while the evidence did not prove conclusively that Judge Caldwell had taken specific corrupt actions in Johnson's case, the circumstances surrounding Caldwell's relationship with organized crime figures and Caldwell's subsequent resignation created sufficient doubt about the fairness of Johnson's trial to warrant a new proceeding. And the decision vacated Johnson's conviction and ordered that he be returned to New York for retrial. This was a remarkable outcome. Convictions were rarely vacated based on judicial misconduct, particularly when the misconduct could not be proven definitively. But the combination of the recording, Caldwell's resignation, and the organized pressure from Johnson's coalition of allies had created circumstances where the federal judiciary concluded that maintaining the conviction would be more damaging to the system's legitimacy than vacating it. The United States Attorney's Office faced a decision about whether to retry Johnson. The original evidence from the 1952 trial was now 5 years old. Key witnesses might no longer be available or might no longer be willing to testify, and the case had generated significant publicity that framed Johnson as potentially the victim of judicial corruption. A retrial would be complicated and might not result in conviction. In March 1958, the United States Attorney's Office announced that it would not retry Johnson. The announcement stated that after reviewing the evidence, the government had concluded that a retrial was not warranted given the passage of time and changes in circumstances. This was bureaucratic language that avoided acknowledging that the original trial had been corrupt, but everyone understood that the government was declining to prosecute because doing so would focus additional attention on Caldwell's misconduct and would be difficult to win. On April 2nd, 1958, Ellsworth Raymond Johnson was released from Alcatraz Federal Penitentiary after serving approximately 4 years of his 15-year sentence. His conviction had been vacated, and he was no longer under federal custody. He returned to New York and to Harlem, where he was greeted not with the parade that would occur after his release in 1963, following another conviction, but with quiet recognition from those who understood what he had accomplished. Johnson had exposed a corrupt federal judge, had forced that judge's resignation, had secured vacation of his own conviction, and had been released from prison through strategic coordination of legal action, media pressure, congressional attention, and civil liberties advocacy. He had accomplished this from inside Alcatraz, one of America's most secure prisons, by patiently gathering evidence, by building a coalition of allies who could act on his behalf, and by understanding how institutions respond to combined pressures from multiple directions. The broader impact of the Caldwell case extended beyond Johnson's individual situation. The exposure of a federal judge accepting payments from organized crime created lasting attention to judicial corruption and to the need for stronger oversight of judicial conduct. The Judicial Council of the Second Circuit implemented new procedures for reviewing judges' financial disclosures and for investigating allegations of improper relationships with parties who might have interests in cases before the court. The Department of Justice launched a broader investigation into organized crime's influence over courts, prosecutors, and law enforcement in New York. But while this investigation produced limited immediate results, proving corruption in specific cases remained difficult. It established that judicial corruption was a serious problem that required systematic attention rather than occasional reactive responses to individual scandals. Within Harlem, Johnson's successful challenge to Judge Caldwell enhanced his reputation as someone who understood how power operated and who could challenge institutional corruption effectively. The case demonstrated that even powerful institutional figures like federal judges were vulnerable when their corruption was documented and when sufficient pressure was applied through proper channels. For the civil rights movement, which was gaining momentum in the late 1950s, the Caldwell case illustrated broader patterns of how the legal system treated black defendants. Even when defendants were actually guilty of the charged crimes, the system's bias and corruption meant that convictions often resulted from factors beyond the evidence. Challenging this required not just defending individual cases, but exposing and reforming the systemic problems that produced unjust outcomes. For attorneys like David Rothstein, who represented defendants in criminal cases, the Caldwell case provided a model for how to challenge judicial misconduct. The key was documentation, gathering concrete evidence rather than relying on general accusations, and building coalitions that could apply pressure from multiple directions. Media coverage, congressional attention, and support from civil rights organizations created circumstances where judicial authorities felt compelled to act. For journalists like Robert Mitchell, and the Caldwell case demonstrated the importance of serious investigative reporting about judicial corruption. Mitchell's articles had been careful to present evidence without making accusations that could not be supported, but they had also been clear about the implications of what the evidence showed. This approach had generated public attention while maintaining credibility. For members of Congress like Adam Clayton Powell, Jr., the case illustrated how congressional oversight could be used to address corruption in other branches of government. Powell's speech calling for investigation had signaled to the Judicial Council and the Department of Justice that the allegations had political dimensions and that failing to address them would generate criticism from elected officials. The recording itself, despite having been obtained through methods that raised legal questions, had served its purpose. It had not been admissible in court, but it had been sufficient to generate investigation, media coverage, and pressure that forced Caldwell's resignation. The recording demonstrated a principle that Johnson understood deeply, that evidence could be powerful even when it could not be used in formal legal proceedings, because evidence shaped public understanding and influenced institutional calculations about costs and benefits. Richard Caldwell disappeared from public life after his resignation. He did not return to legal practice. He did not maintain relationships with former judicial colleagues. He moved out of New York and lived quietly until his death in 1972. His resignation under circumstances suggesting corruption became a permanent stain on his reputation, and his name became synonymous with judicial misconduct in discussions of legal ethics. Anthony Corsaro, the mob associate whose meetings with Caldwell had been documented, also reduced his visibility after the scandal. The Genovese family recognized that Corsaro had become a liability. His connection to a corrupt judge had been exposed, making him less useful as a liaison with institutional figures who now knew he might attract investigative attention. Corsaro continued to work in organized crime, but in less prominent roles. When Bumpy Johnson died in July 1968, 10 years after his release from Alcatraz, obituaries in Harlem newspapers mentioned not just his criminal career, but also his role in exposing judicial corruption. And the Caldwell case was cited as an example of Johnson's strategic intelligence and his understanding that power operated through systems that could be challenged when their corruption was documented and exposed. For legal scholars and historians who later examined judicial corruption in mid-20th century New York, the Caldwell case represented one of the rare instances where corruption was proven sufficiently to force a federal judge's resignation. Most judicial corruption remained hidden or generated insufficient evidence for action. The Caldwell case succeeded because Johnson had recognized the importance of concrete documentation because he had patiently coordinated the gathering of that documentation despite being imprisoned and because he had built a coalition that could use the documentation to apply systematic pressure. The case also illustrated the complex relationship between organized crime and the judicial system. The mob had cultivated Judge Caldwell specifically to ensure favorable outcomes in cases that affected mob interests. Johnson's case had been one such situation. Johnson represented competition and an independent power center in Harlem that the Italian families wanted to eliminate. By ensuring that Caldwell presided over Johnson's trial and took actions that secured Johnson's conviction, the mob had used the judicial system as a weapon. But Johnson had understood this and had turned the system against itself. By documenting Caldwell's corruption and exposing it through proper channels, Johnson had demonstrated that even when the system was corrupted, it retained institutional interests in maintaining legitimacy. When corruption became too visible, institutions would sacrifice individuals to preserve the system's overall credibility. Caldwell had been sacrificed in this way, forced to resign to prevent broader scandal that would have undermined confidence in the federal judiciary. The recording that had exposed Caldwell was never played in open court, contrary to what might have occurred in a dramatic courtroom confrontation. Instead, it had been used strategically, shared with attorneys, journalists, congressional offices, and judicial investigators who could act on the information through appropriate channels. The recording had shocked those who heard it, not because it was played in a public setting, but because it documented what many had suspected but could not prove, that a federal judge had sold his integrity to organized crime. For Johnson, and the victory represented vindication not just of his specific case, but of his broader understanding of how power operated. Institutions claimed to operate according to rules and principles, but they actually operated according to calculations of interest and cost. When maintaining a corrupt judge became more costly than removing him, the institution removed him. When maintaining a questionable conviction became more damaging than vacating it, the institution vacated it. This understanding, that institutional power responded to pressure and cost rather than to justice or morality, was the foundation of Johnson's approach to challenging corruption. He had not appealed to the system's conscience or to abstract principles. He had created circumstances where the system's own interests required action. This was power at its most sophisticated, achieved through patient intelligence, strategic coalition building, and precise understanding of how institutions make decisions. The legacy of the case extended beyond Johnson's lifetime. The Judicial Council's new procedures for oversight, the Department of Justice's increased attention to judicial corruption, the media's greater willingness to investigate judicial misconduct, the civil rights movement's understanding that challenging systemic bias required exposing specific instances of corruption. All of these represented lasting changes that traced back in part to the exposure of Judge Caldwell. The case became part of Harlem's collective memory, not as a story of violence or confrontation, but as a story of strategic intelligence defeating institutional corruption. A black man convicted by a racist judge who was being paid by the mob to ensure that conviction had nonetheless exposed the judge, forced his resignation, vacated the conviction, and secured his own release, all from inside a maximum security prison through careful documentation and coordinated pressure. This was the essential story. That power could be challenged even when it appeared absolute, that corruption could be exposed even when it was protected by institutional authority, and that victories came not from noise or violence, but from quiet, patient, strategic action guided by clear understanding of how systems actually operated beneath their formal rules and public rhetoric.